Vamos a continuar con la programación del 9º Encuentro Internacional de Responsabilidad Civil, tratando de ganarle tiempo al retraso que hemos tenido. Nos corresponde ahora escuchar al profesor Gregory Keating, quien inicialmente tenía previsto una conferencia sobre la prioridad de evitar el daño. Un cambio ha decidido hablar sobre otro tema, va a ser la responsabilidad civil, básicamente en la experiencia angloamericana, la responsabilidad civil objetiva, strict liability in Anglo-American law. That's it. El profesor Keating se graduó en Derecho en la Universidad de Harvard, el doctor de Princeton University, profesor de la Universidad de Southern California, autor de numerosos artículos y varios libros, entre ellos Cases and Materials and Tort and Accident Law, que va por su 4ª edición. Ha sido profesor visitante de las universidades de Tel Aviv, Brescia y Harvard, miembro del American Law Institute, y durante este otoño es profesor visitante de la Universidad de Yale. Professor Keating, thank you very much. You have the word.
Thank you, Max. I want to thank you all for including me in this conference and for being such gracious hosts. I think if the American public knew what a pleasant place Medellín is these days, the TV show Entourage would have plummeting ratings. American tort scholars are quite a parochial bunch. We know something about other common law systems, but very little about civil law systems. I'm hoping, therefore, that my talk does connect with some issues of importance to civil law scholars. The topic I'm discussing, the treatment of strict liability in Anglo-American tort theory, addresses Anglo-American common law debates. I hope it doesn't turn out to be a provincial debate we're having among ourselves. My hope is that strict liability has enough cross-cultural commonality for my topic to connect with some of your interests. Strict liability is not as prevalent as it was in American tort law a generation ago. Lately, strict liabilities have expanded only in connection with environmental harms, and they have contracted in other places, notably in products liability. While the law has been relatively quiet, tort theory has been relatively lively and oriented towards some fundamental questions about the nature of strict liability and its justifiability. This debate starts from the fact that when liability is strict, its imposition does not turn on how much or how little care the actor has exercised. He can be as careful or careless as he likes. Indeed, we might think that the point of strict liability is to hold actors who have acted justifiably responsible for harms they have nonetheless inflicted. The imposition of liability on justified conduct has, of late, made many Anglo-American tort scholars uneasy. They believe that tort liability is liability for wrongdoing, and they therefore wonder if strict liability is a justified form of tort liability. My aim is to explain this debate and then to argue that strict liability is in fact a distinctive and justifiable form of tort liability. American tort scholarship, as Jane mentioned, tends to be quite abstract in general, and it also tends to be somewhat dominated by theory. And it's split between two competing theories. One theory is economic. The other, for lack of a better word, is moral. The economic conception models tort law on the market. It conceives of liability rules as prices, of torts, especially accidental torts, as costs, and it understands tort law as an institution which addresses a pervasive form of market failure. Torts take place mostly among strangers. They are involuntary transactions among parties who do not have bargaining or market relations with one another. The costs that torts inflict are therefore externalities. The role of liability rules is to correct externalities by forcing injurers to take their costs into account and adjust their behavior accordingly. The larger role of the law of torts is to take both the costs of accidents and the cost of their prevention into account, so that victims and injurers are both induced to minimize the combined costs of accidents and their prevention, thereby maximizing wealth. Whatever its faults, the economic conception makes room for both fault and strict liability. To be sure, from an economic point of view, strict liability is by no means necessarily superior to negligence. By virtue of the hand formula's apparent embrace of cost-benefit analysis, negligence liability has the immediate attraction of placing economic theory at the center of accident law. But strict liability has an equally powerful and immediate attraction. By building the cost of accidents into liability rules, it makes liability rules conform more closely to market prices than negligence law does. Whereas negligence modeled on an economic reading of the hand formula replicates the cost-benefit thinking that is the hallmark of market rationality, strict liability replicates the price system itself. Economic analysis thus makes a home for both of these two major forms of tort liability. The moral conception of tort, curiously, fares worse on this score. Prominent moral theorists more or less accept the economic account and conceive of strict liability as a kind of pay-as-you-go form of liability. Paying as you go is not a matter of making reparation for harm wrongly done. It is merely a matter of bearing the costs of your activities. Paying as you go for the harm that you do, therefore, is a matter of mimicking the market and putting resources, including other people's lives and property, to their highest uses. So conceived, strict liability is not a matter of duty, breach, right, wrong, responsibility, and obligation. If torts is a law of wrongs, strict liability, so conceived, is a foreigner in its midst. Agents who inflict efficient injury on others, who pay the proper price for the injuries they inflict and walk away richer, do no wrong. On the contrary, they do the right, which in the economic conception means the efficient thing. Moral theorists of tort are generally committed to the idea that torts are wrongs. Moral conceptions of torts therefore take it as fixed that there are no justified torts. When we label conduct tortious, we're saying that the conduct is unjustified and in that sense wrong. Strict liability is a familiar form of liability in tort. One might therefore expect moral theorists to resist the economic appropriation of strict liability on the ground that it treats tortious conduct as justified conduct and to offer an alternative account. Instead, moral theorists have tended to embrace the idea that strict liability does not involve a wrong and have sought to expel it from the law of torts. John Goldberg and Ben Zapersky, two prominent American tort theorists, illustrate this approach. They write, "We must acknowledge that our insistence that tort law is a law of wrongs puts us in a difficult spot when it comes to explaining the presence of common law strict liability for abnormally dangerous activities. After all, the rationale that seems to prevail in this domain is that liability should attach to activities that are not wrongful in and of themselves, and without regard to whether they are undertaken in a wrongful, that is, careless manner. How does liability imposed in these terms fit within a law that is all about defining wrongs and providing victims of wrongs with recourse? The short answer is that it does not, or so Goldberg and Zapersky say. Their admirably candid answer encapsulates the predicament of most contemporary moral theorists of tort. Strict liability is an embarrassment to their theories. The other alternative, which I will touch on later, is to model strict liability on negligence liability, thereby denying its distinctiveness. I think there's reason to wince at this. One of the principal and persuasive arguments that moral theorists of tort have made for their view and against the economic view is that only a moral conception can make sense of the central intrinsically moral concepts of tort law, concepts such as duty, breach, right, wrong, responsibility, and justice. Broadly speaking, the moral theorists of tort have tasked their economic counterparts with being unable to explain the law of torts from the internal point of view of the lawyer or citizen concerned with the law of torts as a guide to action. From the internal point of view of these actors, the law of torts is a law of obligations. When it comes to strict liability, however, most moral theorists find themselves either confessing that they cannot make sense of it as a form of tortious wrong or shoehorning it into the mode of negligence liability. Any account of tort law that specifies the constitutive features of tortious wrongs in a way which cannot acknowledge or properly characterize strict liability in tort is for that reason, in my view, seriously defective and in need of revision. Two basic forms of strict liability are too deeply embedded in our law of torts to be purged entirely from the field. One form of strict liability is harm-based. The other is based on an impermissible interference with an autonomy right. The first, harm-based form, is found in corners of accident law and in nuisance law. The second, autonomy rights-based form, is found mostly in intentional wrongs to the person or to property. Different meanings of the slippery terms fault and strict are relevant in these two contexts. Harm-based strict liabilities are strict in that they are imposed on justified conduct. That means on harms that it was permissible to impose. Rights-based strict liabilities are strict in the sense that they are imposed on innocent conduct. That is, conduct which, from a moral point of view, we would be inclined to excuse. Moral theorists of tort need to come to grips with both of these forms. To distinguish their view from the economic view, and to register the facts that torts always involve unjustified conduct, moral theorists need to explain why strict liability torts are wrong or concede a limitation in their theory. I believe that this kind of explanation can be given. Strict liability torts are wrongs both because they involve violations of rights, something which can be perilously close to a tautology, and because they delineate two distinctive domains of wrongful conduct, although not wrongful conduct in the sense that the corrective justice and civil recourse theorists in my country, in England, usually have in mind. One domain, the territory of harm-based strict liabilities, involves the distinctive wrong of harming without repairing. The other domain, the territory of autonomy rights, or sometimes called sovereignty torts, involves the distinctive wrong of violating fundamental powers of control over one's person and property. These two forms of strict liability are unified by the fact that they defend autonomy. Physical harm is an assault on one of the basic conditions of human agency, namely the physical integrity of the person, and sovereignty torts involve the violation of core autonomy rights. Harm-based strict liability is illustrated most clearly, perhaps, by the modern American law of intentional nuisance, when it distinguishes between unreasonable conduct and unreasonable harm, and imposes liability for the infliction of unreasonable harm. Unreasonable conduct is conduct which inflicts injury unjustifiably. Negligent conduct, or faulty conduct, is unreasonable conduct. It exposes others to a risk of harm that ought not to have been imposed. By contrast, unreasonable harm is harm which should not go unrepaired by the party responsible for its infliction, even though that harm issued from conduct which was beyond reproach. Unreasonable harm is harm for which an actor is strictly liable. Nuisance law imposes liability for the infliction of unreasonable harm when, as in, at least to Americans, the famous case of Boomer v. Atlantic Cement, It holds that damages should be paid for an unreasonable interference with plaintiffs' rights to the reasonable use of their property, even though the conduct responsible for that interference is justified and in fact ought to continue. By revising the normal remedy for the wrong of nuisance in New York from injunctive relief as a matter of right to damages as a matter of right, and permitting injunctive relief only on a showing of unreasonable conduct, Boomer revises the underlying right. Reasonable conduct resulting in unreasonable interference with another's use and enjoyment of land is wrong only if the party inflicting the interference fails to make reparation for the harm that they reasonably do. Reparation transforms unreasonable harm into reasonable harm and reconciles fairly competing rights to the use and enjoyment of land. Before Boomer, when injunctive relief was available as a matter of right, whenever a plaintiff could show that defendant's activity unreasonably interfered with plaintiff's right to the reasonable use and enjoyment of its land, the primary duty in this corner of nuisance law was a duty to do no harm, full stop. After Boomer, the primary duty is a duty not to inflict reasonable harm without repairing that harm. Other entrenched instantiations of this kind of primary duty include private necessity cases such as Vincent v. Lake Erie, liability for abnormally dangerous activities, liability for manufacturing defects in product liability law, and the liability of masters for torts committed by their servants within the scope of their employment. The legal obligation imposed by all of these doctrines is an obligation not to harm without repairing, even if there is no fault in the infliction of the harm itself. The reciprocal legal right is a right to have any physical harm done to you undone by the party responsible for its infliction. All of these harm-based liabilities are strict in that they impose liability on conduct which is not wrong. They impose liability on conduct that is justified, on inflictions of harm that are reasonable. These liabilities do not condemn the infliction of harm per se. They condemn harming without repairing. Their target is not unreasonable conduct, but unreasonable harm. Negligence liability, by contrast, predicates liability on conduct which is unjustified, on conduct which is unreasonable because it does not show sufficient regard for the property and physical integrity of those that it harms. Autonomy rights-based strict liability imposes liability on not unjustified inflictions of harm in the ordinary sense of harm, but on boundary crossings which may both do no harm and be entirely free of fault. This form of strict liability is epitomized by the torts in the United States of conversion and trespass and by some batteries. Here, the wrong is the violation of a right that assigns a power of control over some valued domain of discretionary choice. The law's specification of various powers of control gives rise to a form of strict liability predicated on the voluntary but impermissible violation of that right. If you enter my land or appropriate my pen without my permission, you violated my right of exclusive control over these objects. Even if your entry is entirely reasonable and justified, the wrong consists in the failure to respect the right. Fault is simply irrelevant. If you enter my property under an entirely reasonable and innocent misapprehension of where the boundary between my property and yours lies, you trespass. You need not even know that you have entered my property without my permission, much less intend the wrong of entering my property without permission. You need intend no wrong, and you need do no harm other than the harm of violating my right over control, my right of control over my person or my property. Indeed, you may benefit me. One prominent case involves a defendant who trespassed thinking that certain trees were on his property, and he trimmed them and cleaned them of bagworms. That's clearly a benefit to the plaintiff. You may also trespass if you're innocently and reasonably mistaken about which building you have permission to use as a set for your movie, an old Los Angeles case, or if you're simply mistaken about the scope of the permission that I've given you. And you may convert my chattel simply by exercising dominion over it in a way which is in denial of or inconsistent with my rights. You do not need to intend to deny my rights or even know that you are. Liability for battery may likewise be predicated on innocent intentional touchings, and even on touchings that benefit those who are touched without their consent. Medical batteries in particular can take this form. A patient can be operated on without her consent, and her diseased condition can be cured. She's benefited by the cure, even though her right of control over her own person is violated. There are two lessons here. One is that intentional torts do not categorically represent a more egregious form of fault than negligence torts. Paradigmatic intentional wrongs, to be sure, do have the character of being more egregious. They are governed by the aim of inflicting harm on the victim in violation of her rights. The wrongdoing involved is worse than negligent wrongdoing. Negligence involves only objectively insufficient regard for the victim. Paradigmatic intentional wrongs involve both intended harm and knowing disregard of the victim's rights. They express contempt for the victim, which is often more unbearable than the harm itself. The law of intentional torts, however, is not restricted, at least in the United States and England and other common law countries, to wrongs whose commission entails the expression of an intense and objectionable disregard for rights of their victims. Batteries, trespasses, and conversions can all be committed without intending either the wrong or the harms involved. The intention need reach only as far as the action which impermissibly crosses a protected boundary and no further. This is because the rights in question are autonomy rights. They are rights to exclusive control over one's persons and one's property, real and movable. Liability for a violation of a right of exclusive control is strict for the simple reason that the right itself would be fatally compromised by tolerating all reasonable or justified boundary crossings without regard to whether consent was given to those crossings. If you were to pursue this issue a bit and think of it in economic terms, you'd have a puzzle as to why it wasn't permissible simply to take other people's property whenever you could put it to a higher use and thereby increase wealth. Why exactly would you need people's permission if you could get the efficient outcome? The answer implicit in the law is because this is about autonomy, not efficiency, and autonomy requires here strict liability. In any case, in this class of cases, the strictness of liability in tort is a reflex of the relevant rights. The difficult normative questions raised by these torts are mostly questions of responsibility. Why exactly is it permissible to hold someone accountable for innocent conduct which they could not reasonably have been expected to avoid? For present purposes, I want to put this difficult question aside and comment on the relation of these torts to what moral theorists of torts call conduct-based wrongs. In cases where liability is strict and sovereignty-based, the wrong committed is conduct-based in only the most attenuated sense of the term. In negligence, which is the canonical example for most tort theorists of a conduct-based wrong, liability is predicated on the wrongfulness of the defendant's conduct. The wrongfulness of the conduct, the breach of the duty, does the work and triggers liability. In sovereignty torts, it is the violation of the plaintiff's right that does the work and triggers the liability. The duty, if we want to speak of it, is a duty not to violate the right, and any intentional action which violates the right is therefore wrongful. Viewed in isolation from the right, however, the conduct may be innocent and even justified. The defendant Doctor in Moore v. Williams, a medical battery case, benefited the plaintiff by curing her disease. The wrongs in cases like Moore are wrongs only because they violate rights. They do no harm other than the harm done by the violation of the right. and they express disrespect insofar as they do in fact disregard important autonomy rights. Harm-based strict liabilities of the sort found in intentional nuisance law, that's the case of Boomer as an example, abnormally dangerous activity law, and some parts of product liability are different. These strict liabilities involve a more robust form of wrongfulness. They're torts whose wrongfulness lies in harming without repairing. The distinctive character and morality of these strict liabilities is also obscured by contemporary tort theory, with its preference for fault liability and its insistence that tort is a domain of conduct-based wrongs. Contemporary moral theorists of torts show either the inclination to expel these torts from the law of torts proper, or to absorb them into the architecture of negligence wrong. Goldberg and Zapersky exhibit the first inclination, claiming that it's merely a matter of convention that we call this kind of liability a tort. When harm issues from an abnormally dangerous activity and strict liability is imposed on the party engaging in that activity, neither the activity in which the injurer is engaged nor their conduct in inflicting the injury are wrong. Harm-based strict liabilities do not involve wrongs, and therefore they're not really torts on this view. The legal philosopher Jules Coleman assimilates this form of strict liability to negligence by casting the duty involved as a duty to do no harm, full stop. So instead of having a duty not to inflict harm unreasonably, you just have a duty not to inflict harm. Neither Goldberg and Zapersky's expulsion of harm-based strict liability from tort law proper, nor Coleman's absorption of such liability into negligence does justice to this form of liability. The wrong involved is a conditional one. Harm-based strict liabilities occupy a space that negligence liability tends to eclipse. In negligence, the obligation to repair arises from the infliction of harm which should have been avoided. In strict liability, the obligation to repair arises from the infliction of harm which should not have been avoided, that is, which it's okay to impose, but which should have been repaired and borne by the party responsible for its infliction. In the circumstances where they govern, harm-based strict liabilities assert that it is wrong for an actor to do harm without stepping forward and making good the harm done. The primary duty that harm-based strict liability institutes is therefore not a duty to do no harm, as Coleman thinks. It is a duty to make reparation for any harm done, even though due care has been exercised. It is a duty, to put it differently, not to harm without repairing. Failing to make reparation evinces insufficient regard for the rights of the person harmed, even though the conduct responsible for inflicting that harm is beyond reproach. Now, for the theorist I'm talking about, a conduct-based wrong is one where a right is violated when an agent fails to conform her conduct to the standard required by the law. Fault-based liability is the canonical illustration. It predicates responsibility for physical injury on the judgment that the defendant failed to conform her conduct to the standard of reasonable care. Conduct-based wrongs express what I shall call primary criticism of conduct. The law lodges its criticism against the infliction of harm in the first instance on the ground that the conduct responsible for the harm was wrong. The harm, therefore, should never have occurred. Strict liability, harm-based strict liability, by contrast, predicates responsibility on the judgment that the conduct at issue was justified or reasonable in inflicting injury, but unjustified or unreasonable in failing to repair the injury done. This is what I will call secondary criticism of conduct. The law larges its criticism against harming justifiably without repairing. This kind of strict liability identifies a conditional wrong. It circumscribes a domain within which the infliction of harm is justifiable, but only on two conditions. One, that the conduct inflicting injury is justified or reasonable, and two, that reparation is made for physical harm done by that reasonable conduct. Conditional privilege in the law of private necessity, a doctrine which takes different forms in the different common law jurisdictions I know nothing of what form it takes in civil systems, or even if it exists. I know it exists. I take that back. But conditional privilege, as embodied by the case of Vincent v. Lake Erie in the United States, illustrates this difference between primary and secondary criticisms of conduct. The defendant ship owner, Vincent, involved a ship that was docked at a port and had finished unloading its cargo, and its contractual right to be docked had expired, but a huge storm came along, a tempest, as in Shakespeare. And the ship continued to stay lashed to the dock and, in fact, retied itself to the dock, and as a result, the dock was damaged. The defendant ship owner's conduct in lashing its ship to and damaging plaintiff's dock was reasonable, not unreasonable. It was right, not wrong. The defendant had the right to use the dock to save its ship from destruction at the hands of the storm, even if using the dock involved damaging the dock. That's part of the holding of the opinion. The defendant's privilege to trespass was not conditioned on doing no harm to the dock, a requirement which would have been impossible to meet in these circumstances. The defendant's privilege was conditioned on making reparation for any harm done to the dock, even though that harm was done rightly and not wrongly. The wrong in Vincent lay not in the defendant's doing damage to the dock, but in the defendant's wrongful or unreasonable failure to step forward and volunteer in the aftermath of the storm to make good the damage done to the dock. Put differently, Vincent's strict liability is liability for unreasonable harm, not liability for unreasonable conduct. In Vincent, making reparation for the harm done by continuing to dock during the storm prevents the injustice of shifting the cost of the ship's salvation from the ship owner who profits from it onto the dock owner who does not. The imposition of liability on the ship owner for failing to make such reparation rights the wrong of shifting the cost of the ship's salvation onto the dock owner whose property is the instrument of that salvation. So what we have here is the wrong of harming justifiably, but unjustifiably failing to repair harm justifiably done. Generalizing from Vincent, we can say that the wrong involved in harm-based strict liabilities is akin to the wrong in restitution. In restitution, the basic wrong consists of retaining a benefit whose retention unjustly enriches its recipient at the expense of the party conferring the benefit. In harm-based strict liabilities, the basic wrong consists of benefiting from the reasonable infliction of harm on another who merely suffers from its infliction, that is, they don't share in the benefit. The role of reparation is to undo that wrong by erasing the harm. When reparation is made, the injurer no longer benefits through harming the victim. Structurally, in America anyway, harm-based strict liability in tort resembles eminent domain in public law. Eminent domain law holds that it is permissible for the government to take property for public use only if the government pays just compensation to those whose property it takes. This is a two-part criterion. First, the taking must be justified. That is, it must be for a public use. Second, compensation must be paid for the property taken. Strict liability in tort, as we've seen, has a parallel structure. In negligence, the defendant's primary conduct determines liability, and it does so only when the conduct is wrongful. In strict liability, the defendant's conduct triggers liability when the defendant's failure to step forward and repair harm faultlessly inflicted is wrongful. Strict liability thus asserts that the cost of necessary or justified harms should be borne by those who benefit from their infliction, and not by those whose misfortune is to find themselves in the path of someone else's pursuit of their own benefit, however reasonable that pursuit may be. Harm-based strict liability thus involves a distinctive morality. It involves both fairness or justice and wrong or rights violation. To say that it is unfair for an injurer to thrust the cost of its activities onto a victim is not the same as to say that the victim's right is violated by doing so. I have an example from a famous Old English nuisance case, which I don't know if you read, but maybe you can glean the facts. It may, for example, be unfair for me to rebuild my house and block the passage of air through your chimney. Imagine a world in which chimneys are the primary source of heat. The loss to you may be great and the gain to me may be trivial. Let's just suppose that's true. Unless you have a right to the passage of air across my property, however, what I have done is not a legal wrong. Strict liability, as we find it in our law, is thus justified both by the principle of fairness that those who benefit from inflicting harm on others should also shoulder the cost of that harm, and by the further claim that the harm done is the invasion of a personal or property right, the right to the physical integrity of one's person, or the right to be free of unreasonable interference with one's use and enjoyment of land. It was that latter right that the plaintiff couldn't make out in the chimney case I just discussed. Because there is a right involved as well as unfairness, failure to make reparation for harm done would be a wrong. Strict liability thus asserts that an injurer subject to a regime of strict liability does wrong, and this is the point the moral theorists generally miss, when the injurer fails to step forward and repair harm rightly inflicted. And it makes this assertion because leaving the cost of the harm on the victim who suffers it shows insufficient respect for the victim's rights of property in the case of both nuisance and the conditional privilege of private necessity. Let me jump because time is limited. I gave myself a note of where to cut out and not where to start again. All right, so let's see. So let me comment here, jump to another part of my paper if you have it, and comment on the relation of this to theories of justice. I've argued so far that strict liability wrongs involve both a wrong, that is a violation of a right, and unfairness in failing to bear the cost of repairing harm reasonably inflicted. One thing I haven't done is to say just when the wrong is or when it occurs. This is a problem that troubles theorists of tort. In my view, the wrong lies in failing to repair the harm when the actor's responsibility for that harm becomes clear and the obligation to repair is therefore part of the primary norm governing the conduct in question, not part of the remedial norm. To put the matter in the corrective justice terms favored by some tort theorists, the wrongful interaction is the interaction which takes place when the injurer fails to step forward and to repair harm for whose infliction the injurer is, all things considered, responsible, because the harm may be fairly charged to the injurer's activity. The wrong involved in harm-based strict liabilities is the wrong of benefiting from the reasonable infliction of harm on another in violation of her right and at her expense. It's committed when a reasonable injurer would have recognized and acted upon its responsibility to repair. The lawsuit therefore enforces a pre-existing duty of repair, just as a negligence suit does, albeit a different pre-existing duty of repair. On this account, the morality of harm-based strict liability wrongs makes strict liability corrective in a fundamental way. It undoes interactions that involve one person who benefits herself by reasonably harming another person. In this sense, there is no logical incompatibility between strict liability and corrective justice. One of the things that worries moral theorists is that there might be such an incompatibility because of the innocent conduct involved. However, the truth is quite the opposite. Strict liability in tort embodies corrective justice. However, it's equally important to see that strict liability in tort also goes beyond corrective justice because it also rests on a principle of fairness, a principle of who should fairly bear the costs of certain harms that should not be forbidden. The principle is an old and familiar one. The party who stands to benefit from some voluntary choice, such as the choice to rescue your ship in a storm by lashing it to someone else's dock, should also bear the burden of that choice. This is true even if the choice is reasonable and the burden is one that is reasonable to impose. There's an American expression that covers this, which is, you have to take the bitter with the sweet. The fact that it is reasonable to impose a risk does not mean that it is reasonable to ask just anyone to bear the cost of the harm that may result from the imposition of that risk. Fairness says that it's fairer to require the party who stands to benefit from the imposition of a reasonable risk to repair the harms resulting from that risk than it is to leave those harms unrepaired on the shoulders of those who are merely unlikely enough to have gotten in the way of someone else's useful activity. This puts us in a place to see the basic morality of strict liability in contrast to the morality of negligence law. Negligence law embodies a morality of responsibility for harms that should have been avoided. It says that when harms should have been avoided, the party who breached her responsibility to avoid them should be held responsible for repairing those harms. Strict liability, by contrast, is a morality of responsibility for risks that should not have been avoidable. It's a morality of responsibility for unavoidable harm in one sense of the word. It holds that when harms result from justified conduct, the party who is responsible for and stands to benefit from the infliction of those harms should repair those harms and should shoulder the cost of so doing. Failing to do so is wrong. There is room for these principles to conflict, and you might think that in principle, these principles conflict all the time. They're opposing principles of responsibility. But as long as they're a domain of significant harms whose affliction should not be avoided, there'll be a domain where strict liability is attractive because there is a question of what should be done with the costs of harms, who should be responsible for repairing harms that should not be avoided. And the morality on which strict liability rests has the same intuitive attractiveness as eminent domain does in the public law context. So in all of this, I think we have reasons to think that there is nothing anomalous about strict liability as a form of liability in tort. It is, in fact, a morality of responsibility for harm done, or in other cases, it's a morality of responsibility for violating rights whose nature does not permit innocent or justified violations, because the permission of innocent or justified violations would, in fact, restrict the right dramatically and unjustifiably. It's just the case that when someone has an autonomy right, it isn't okay to violate that right simply because you act reasonably. If you think about that principle, you can see it would have applications in all kinds of domains, such as paternalism. So let me conclude by thanking you again for inviting me and hoping that these parochial debates in American tort scholarship have some relevance to the thinking and discussion and application of strict liability in civil legal systems. Thank you.